With and on behalf of Mr. Hall, who appears via Zoom from the Macomb County Jail. Sir, can you please state your name for the record?
Eric Dwayne Hall.
Right out of the gate, this courtroom session sets the tone for what's about to unfold. And trust me, this is not your typical clean-cut sentencing hearing. We've got multiple defendants, multiple legal issues, and a judge who is clearly not here to waste time. First up, we're dealing with Mr. Dwayne Hall, appearing via Zoom from jail, already a signal that this case has layers of complication both legally and personally. Now here's where it gets interesting. The recommendation on the table is time served. That's usually a huge win for a defendant. It means no additional jail time beyond what they've already done. But as simple as that sounds, nothing in court is ever that straightforward. Because even when the jail time is settled, the system still comes knocking with fines, fees, and legal obligations that don't just disappear. Wish it and watch closely. Because what starts as a routine sentencing discussion quickly turns into a deeper look at something the legal system struggles with constantly. What happens when someone simply cannot pay? We're talking homelessness, financial hardship, and a defendant trying to navigate a system that doesn't always bend for personal circumstances. But that's just the beginning. As this video unfolds, you're going to see competency rulings, bond violations, drug test failures, and a judge making firm decisions that carry real consequences. Every moment builds tension, gardind, and every decision matters. So pay attention, because by the end of this, the question isn't just what happened in court. It's whether justice actually played out the way it should have.
Thank you. Thank you, Your Honor. Today's the date and time set for sentencing this matter. I have received and reviewed the PSIR as well as the recommendation this week. However, since I did receive that, I had not been able to have an in-person visit at the Macomb County Jail with Mr. Hall. I will state for the record that the sentencing recommendation is for time served as well as the statutory minimum fees. So I will leave it up to Mr. Hall whether he would like to proceed today and ask the court to adopt that recommendation, or if he would like to adjourn the sentencing so I can meet with him now that I have the PSI. So Mr. Hall, this is the 2019 case that you pled to, and the sentencing recommendation is for time served. I got just that report this week. We can adjourn your sentencing out so I can come down and meet with you and discuss it, unless you were comfortable proceeding today, understanding what the recommendation is.
Time served?
Yeah, the sentence I would impose are the statutory minimum fines and then the credit.
What's the fines?
For time served.
What's the fines?
This moment right here is deceptively simple, but it carries serious weight. The judge lays it out clearly. Time served is granted, but the statutory minimum fines still apply. That means $125 on one count and $50 on another. Now, legally speaking, the judge isn't making a discretionary decision here. These are mandatory minimums set by law. In other words, the judge's hands are tied. But look at Mr. Hall's reaction. He immediately pivots to asking if there's any alternative, like community service. That tells you everything about his situation. This isn't someone trying to dodge responsibility. This is someone who literally doesn't have the means to pay. And here's the bigger issue. The justice system often assumes financial penalties are manageable. But what happens when they're not? When someone has been homeless for years, even a relatively small fine becomes a massive barrier. The judge's response is blunt. Yes, technically you can petition the court, but realistically, nothing is going to change. That's a hard truth moment. Now think about this. Should courts have more flexibility in cases like this? Or are strict rules necessary to maintain fairness across the board? Because situations like this sit right at the intersection of law and reality, and they don't always align cleanly.
It's on count one, it would be $125, and the other would be $50. There's nothing I could do about that. Those are set statutory minimums.
Is there any way I could do community service for those? On release?
You could, but you'd petition the court, but we're not going to really do anything with those, quite frankly.
Okay, so can I ask my lawyer a question about this habeas corpus that I had sent in? It was saying basically y'all had to get back with me within 10 days or dismiss it. Is that?
So Mr. Hall, I believe that's about a different case. Yes, Your Honor. That might be for a different case, but maybe for this case, if we request an adjournment.
That's for this case. I sent in habeas corpus, one habeas corpus for both of those.
I don't want you and your attorney to have discussions publicly this way. If you want me to adjourn your sentencing, I will adjourn it and we'll set it for another day.
Okay.
Or we can proceed today. It's up to you.
I mean, it's going to be the same charge, so I'll adjourn it to see if what else can I do? Do not have to pay that fine because I don't have it, and right now, even if I was once I got out, I've been homeless for like the last 8 years, so it's like so.
So Mr. Hall, we kind of. Sorry, Mr. Hall, I don't mean to interrupt, but we can adjourn it so I can have a discussion with you, just so you know the recommendation won't change, but we can absolutely discuss it so we can have a private conversation. So the judge did say he would adjourn it for us.
Yes, ma'am. Thank you.
You want it adjourned?
Yes, sir.
And just like that, the decision is made. The sentencing is adjourned. Now on paper, this might look like a delay with no real impact. The attorney even said it herself. The recommendation isn't going to change, but don't underestimate what just happened here. An adjournment buys time, and in the legal world, time can be everything. It allows the attorney to meet privately with Mr. Hall, go over the PSIR, that's the pre-sentence investigation report, and make sure he fully understands the situation. It also gives them a chance to explore any possible legal angle, even if the odds are slim. But here's the emotional layer. Mr. Hall openly admits he's been homeless for 8 years. That changes how you view this entire interaction. This isn't just about fines anymore. It's about survival. And the judge, calm, procedural, actually respectful, but firm. No promises, no false hope. Just a clear path forward. Now ask yourself this. If you were in Mr. Hall's position, would you have taken the adjournment or just accepted the outcome and moved on?
Okay.
Thank you very much, Your Honor.
I'll adjourn this sentencing to May 14th, 2025, 9 a.m.
Okay, thank you. God bless you. Have a good day.
Thank you, Mr. Hall. I'll be down to see you, okay?
Okay.
Thank you.
Court calls the case, People versus Jacob Spelling. Thank you, sir.
Your Honor, our office has received a copy of the competency evaluation in this matter. Have gone over it with Mr. Stewart, and we are not objecting to the findings of that report.
I am objecting. That the defendant at this time is incompetent to stand trial, but with treatment would likely regain competence within a statutory period of time.
Yes.
This is a major shift in tone. We move from sentencing into competency evaluation, and legally, this changes everything. When a defendant is found incompetent to stand trial, it means they currently lack the ability to understand the proceedings or assist in their own defense. That's a fundamental requirement in the justice system. But notice the second part, with treatment would likely regain competency. That's critical. This isn't a permanent ruling. It's temporary, and it triggers a completely different legal pathway. Instead of moving forward with trial, the court pauses everything and focuses on treatment. The judge schedules a review hearing 3 months out. That's standard. It gives time for mental health professionals to work with the defendant and reassess. Now here's the underlying tension. This system is trying to balance justice with mental health realities. You can't prosecute someone who doesn't understand what's happening, but you also can't ignore the charges. So the court hits pause. And this raises a bigger question. Where should the line be drawn between accountability and mental capacity? Because cases like this sit right in that gray area.
Any other additional evidence from either side?
No.
I need it 3 months because excuse me. Set a competency review hearing July 24th, 2025 at 9 a.m. Counsel, you'll prepare the requisite order.
Yes, and Your Honor, if I could briefly address bond.
Yes.
So I, for whatever reason, in on-base, I'm not able to find the most recent community corrections bond order. But Mr. Stewart is on some kind of a GPS tether at the moment. I'm not sure if it's just tracking or if it's an exclusion zone. That is both very uncomfortable for him, and because he currently doesn't have housing, it's very difficult for him to make sure that it's charged to get somewhere where he can plug it in. I will note that he has been, at least the last few times that I've represented him, he has appeared on time for court. Nothing by way of new offenses. He's compliant on bond. He would just ask Your Honor to consider removing that tether.
Can you respond from people?
Your Honor, I understand it may be uncomfortable, but unfortunately, the nature of these allegations seem to require it. Mr. Stewart is charged.
I'm disabled. What am I?
Pay attention to the jail.
It's y'all world. I'm just in it.
May I continue?
Go ahead.
The nature of these allegations appear to require it. Mr. Stewart is charged with one count of witnesses bribing, intimidating, and interfering. Essentially, the allegations in this report describe Mr. Stewart. These are physical confrontations in terms of rushing this individual in this area. Now, him no longer living, I think, close by may assist with that, but I don't have any assurance that Mr. Stewart is going to be able to essentially not contact this person. I might feel differently if we were dealing with text messages and emails and phone calls and that sort of thing. These are physical confrontations.
Your Honor, I do believe Mr. Stewart is no longer living at that location. This incident occurred back in 2022. At the time, I believe Mr. Stewart was still at that apartment complex. He had since been evicted and isn't staying there anymore. It's my understanding that you are usually in downtown Ann Arbor, or Delano Center as his mailing address. Okay. But either way, I don't think he plans to or has been going back to that location.
Well, he evicted me. Why should I go back?
All right. The original order, that's what may help, is, at least as I see it, the original order was back on September 21st of 2023. However, there was a period in time at which, for whatever reason, as it was proceeding, it came through, and then I think at some point the defendant bench warranted, and there were some other issues. At later date, I then set aside the bench warrant, reinstated his previous bond conditions, which is why he has the tether on now. Okay. So I'm a bit reluctant. Well, what I'm going to do is this. I'm going to deny your request at this moment. And what you would need to do is file a written motion that I can consider fully as to the release, where he is, and lay all of that out to me. So at this time, the motion for bond modification is denied. Thank you.
Okay.
This is a textbook example of judicial caution. The defense is asking for the GPS tether to be removed, arguing that it's uncomfortable, difficult to maintain due to homelessness, and unnecessary given the defendant's compliance. On the surface, that sounds reasonable. But then the prosecution lays out the allegations: witness intimidation, physical confrontations, and a lack of assurance that the defendant won't reoffend. That changes the equation completely. The judge doesn't just say no. He explains how to try again. File a written motion, lay out the full argument, provide evidence. That's due process in action. And here's the key. Judges don't make decisions based on sympathy alone. They weigh risk, public safety, and legal standards. Right now, the risk outweighs the convenience, so the tether stays. And this is where you see the system's priority: prevention over comfort.
Thank you.
Bond will continue.
24th of July.
Yep.
is that what it is? Okay. I don't know what it is.
State your name for the record, please.
Victor Morris Sharaf.
Your Honor, in regards to the probable cause conference, we're requesting an adjournment. There was still some outstanding discovery that we requested.
You have a green sheet? No.
I've got it right here, though.
I don't mind it now, but we do have a problem. House Conference 2025. As to the bond violation.
As to the bond violation, and I did have an opportunity to speak with Mr. Gerard. Your Honor, he takes full accountability. He's indicated to me that he has been struggling with depression, and obviously now knowing that this issue is much bigger than we talked about treatment opportunities. In the report from they did indicate that they have made a referral for CCOP on his behalf as well. He has not spoken with Mr. Brown to see where they are with that program, but I just asked the court to at least give us the opportunity to explore that option and see if we can get him into outpatient treatment.
No, you might be able to get him into outpatient treatment, but he's clearly in violation because they have had 4 successive tests where he's positive for cocaine, amphetamines, and then his last test positive for cocaine and alcohol. But before the confirmation test on the alcohol, he left the building.
And I did ask him about that, Your Honor. I think that was just a misunderstanding. He stated that he did not know that they needed him to stay in the building to do any other follow-up tests. But I've explained to him that once there is a positive alcohol test, that they require the confirmation test.
All right. Anything else?
Nothing else.
So I set it for May 6, 9 a.m. At this point, defendant's bond is revoked.
Thank you.
This is one of the most decisive moments in the entire video. Bond revocation is serious. It means the defendant loses their freedom pending further proceedings. And the reason here is clear: repeated violations. 4 successive positive drug tests, cocaine, amphetamines, and then alcohol. That's not a one-time mistake. That's a pattern. And in the eyes of the court, patterns signal risk. The defense tries to explain depression, misunderstanding about the testing process. But at this stage, explanations aren't enough. The judge is looking at compliance, and the record isn't helping the defendant. And here's something important. Bond isn't a right, it's a privilege. It comes with conditions, and once those conditions are violated consistently, the court steps in. Now consider this. Should the court have given one more chance because of the mental health struggles, or was revoking bond the only logical move here? Because decisions like this aren't just legal, they're judgment calls with real consequences.
Green sheet now, we're asking for an adjournment in this matter. Mr. Swope has been having some medical issues, so he was in and out of the hospital. Well, he was in the hospital. We weren't able to have contact with him. Obviously, he's here. I'll confirm his contact information and see if we can figure out what's going on this case and come to a resolution with the people. We are in communications with them in regards to a resolution, but we have not been extended an offer yet.
Go ahead.
I think that before we get to the adjournment, we should perhaps address bond. There was the violation report sent out indicating that Mr. Swope was released and on April 12th, and that he was supposed to be reporting to community corrections, which he never did. He did not go to community corrections for intake, let alone the 2 times a week testing that he's supposed to undergo, Your Honor. My understanding is that Mr. Swope did not have money, Your Honor. So it does not appear that there is a legitimate reason for Mr. Swope not showing up. At the very least, for intake, he will be putting up or to pay for some particular tests. And my understanding is that he'd still be able to test. He just might end up owing some money. So, Your Honor, at this time, I believe that Mr. Swope is in violation of his bond conditions, and that perhaps a remand would be appropriate. It's good that he came today. However, we have no idea whether he's been using substances during this time and how or why he did not even show up for anything.
And Your Honor, I did have a conversation with the people in regards to that. She didn't ask what the reason for his failure to report was, and everything that she stated is correct. I spoke with Mr. Swope. He stated that he did not have any money and he thought that he was required to present money at community corrections. Now, if there's a change in the rule, I did tell him that we still encourage our clients to go and form community corrections.
He needs to go.
Yeah.
He just hasn't done anything.
Sure.
Is he working?
He's working right now, Mr. Swope. No, he's not, Your Honor.
If I were to test you right now, you're going to test clean? Don't. You're not. I didn't think so. Mr. Adams. Grant your adjournment. I'll set this probable cause conference for May 6th, 2025, 9 a.m. At this point, defendant's bond is revoked. Defendant's remanded.
By the end of this courtroom session, the pattern becomes clear. This is a system responding to repeated instability across multiple cases. We saw a defendant struggling financially, another dealing with competency issues, and others facing bond violations tied to substance use and non-compliance. Judge Simpson maintains a consistent approach throughout, measured, procedural, and firm. When the law allows flexibility, he explains it. When it doesn't, he enforces it. And when defendants fail to meet conditions, the consequences follow. Legally, every decision here aligns with standard courtroom practice. Statutory fines must be imposed, competency must be evaluated before trial, and bond violations lead to revocation. But beyond the legal framework, there's a deeper theme running through all of this: the challenge of balancing law with human circumstances. Homelessness, mental health, addiction, these aren't just side notes. They're central to why these cases unfold the way they do. And that's what makes this courtroom session so compelling. It's not just about rulings, it's about reality meeting the legal system. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.